Ladies and gentlemen, thanks very much for the opportunity to tell you a little bit about the European side of these international disputes that we have already heard about. I would think, in my personal experience, it started some 10 to, let's say, 15 years ago, that the major disputes almost always have a US and a European leg, and that the European side is almost always a German litigation, especially in patent litigation. I think one of the first big cases was the Rambus case regarding the DRAM, SDRAM market that was filed, I think, 10 or 11 years ago in the Mannheim court and in the US courts. That has gone on, and today, as we have heard, we have the big litigation of Apple versus Samsung. We have had Nokia versus Apple. We've had Sony versus LG, and all of these cases were pending or are still pending in the US and in Europe, and in particular in the German courts in Europe. Another aspect of these cases is that not only have they become more global or international, but they have become much more complex. And by complex, I mean not only technically more complex, but they tend to involve many more IP rights. And that's, for one, on the patent side. So if you as a plaintiff file a case, that would usually not only involve one patent, but multiple patents, and it would involve multiple products and multiple aspects of a certain technology. But it's also involving many more other IP rights, like design rights, that have been particularly important in the recent cases involving Apple. And so therefore, in my presentation today, I want to give you an overview of the European system, because it's very important to understand and to distinguish which rights are available and in which court structure to assert them, because that has a significant impact on the prospects of success and on the relief that can be granted. So in the first part, I'm going to cover the three basic categories that we have. We have unitary EU rights, then we have European patents, that is a separate category, and we have traditional national IP rights. I will then go on and explain a little bit about the advantages of litigating IP rights in German courts. I will describe in more detail the basic aspects of a German civil action, a German infringement proceeding. And in the last part, I will explain a little bit more about the basic structure of the patent system, especially about the principle of bifurcation and how the validity side works and how that plays out for this for strategy decisions in these types of cases. Coming to unitary EU IP rights, unitary IP rights are available. You have EU design rights and EU trademarks, which are traditionally known under the name of community design rights or community trademark rights. So these are rights that are valid throughout the European Union, are not limited to certain contracting states like for a European patent. However, and that is very important, there is no general court structure where you could litigate infringement claims. There is a unified registration and opposition proceeding, and you can file certain nullity actions in the competent EU courts, but there is no EU venue for civil actions. And that is a big difference to, for example, the US system. Yeah? Of course, if there is a US patent, you can litigate the infringement of that patent in a US federal court, and you would be granted a US-wide relief. But there are no EU courts for civil actions. And that's not only true for this field, that's true in general. There are no EU civil courts. That is a step that has to be made at a certain point, and the patent field could be the first field where this step might be made. So infringement is for the national courts to decide, also for unitary IP rights like a community design right or a trademark. There are jurisdictional rules in the EU regulations, in the pertinent EU regulations, and the basic distinction in all of these regulations, not only in the specific ones that I've mentioned, but also more generally, is that a court of general jurisdiction can grant an EU-wide relief, so an injunction enjoining the defendant from selling the device throughout the European Union. And the court of specific jurisdiction can only render a relief that is limited to its jurisdiction. So even though you have an EU right, a unitary right, you might litigate it in a court that could only give you a limited jurisdiction. That, I would think, is not possible in the US, when you have infringing activity in a state and you have therefore jurisdiction. That court could grant a relief, would have to grant a relief that applies US-wide. An example is the Apple-Samsung case that is just pending in the Düsseldorf courts. It's very interesting because that is a design aspect of that bigger dispute. And Apple filed an ex parte application for injunctive relief and requested EU-wide relief against Samsung Korea and against Samsung Germany. So two defendants, the parent company in Korea and the subsidiary in Germany. And the court, the Düsseldorf court, granted EU-wide relief in a preliminary injunction proceeding, ex parte, only to mention that, against the German entity only, because they said, okay, the German entity is domiciled, it has its principal place of business in Germany, and therefore we can grant EU-wide relief. For Samsung Korea, we have only specific jurisdiction relating to the infringing activities in Germany, so the relief would have to be limited to Germany. In this connection, I also mention something more general, which relates to John's presentation. He has explained in how far the jurisdiction analysis is very case-specific and fact-specific. You have to analyze all the facts relating to that case. That is generally not the case in Europe or in Germany. So general jurisdiction we would only assume if the defendant has its domicile in the relevant forum here in Germany, and in no other cases. Yeah, there are certain exceptions that are not really relevant, and specific jurisdiction we would assume as soon as there is an infringing activity in the forum. And in this regard, it might be interesting to mention that that does not mean that the defendant would actually have to carry out in the forum personally certain acts. Rather, it would mean that whenever there is a potential infringement of a German right, or here an EU right, in the forum, then there is specific jurisdiction. Now, a good example is, let's say in the automotive industry, and I've litigated several of these cases, you have a supplier a supply of a certain part of a car, and that supplier is based in Japan and would supply that part to a Japanese car maker. Of course, knowing that this part might eventually also end up in Germany. So putting it into the stream of commerce, as John mentioned it in his presentation, and being aware that this product might be imported by the downstream customer into the German market. The German courts have always held that this in itself is sufficient to establish jurisdiction and is sufficient to qualify as an infringing activity in Germany. So the defendant, even though purely acting in Japan and not directly in Germany, and also not having direct control over the actual importation into the German market, would still be held liable for infringement of a German patent. So that's very important to realize. It's also important to realize in this connection that the UK courts, take a different approach. Yeah, they think that only if you directly import it, or if you have some sort of what they call common design, which is similar, I would say, to joint tortfeasors, then you would be personally liable for infringement in the UK. So you see, but that would, here in our example, the German court would apply its own set of rules on infringement here. A UK court might apply its rules. So despite the fact that there is a unitary IP right, you might, for these cases, end up with different decisions just because there is no unitary court system.